independent pizzerias. And it talks about how the number of pizzerias have gone down dramatically, the small one, independent ones, because of technology. This is what our next panel discussion really should be about. But anyway. All right, so I'm very happy to be involved with this panel. I'm happy because there's 3 of my former students as commentators. Tom was on our faculty many years ago, started his teaching career. And I'm sorry, Mercer, but you're not Brooklyn, but his daughter lives in New York. So
and I'm a Red Sox fan, too.
Oh, well. Anyway.
Love Bill Buckner. Love Bill Buckner.
So we'll begin as we've done previously. Each speaker who's written a paper will talk about 20 minutes or so, 25. I'll keep a warning of 5 minutes. And then we'll have the commentators and then opening up to discussion. And the first speaker will be Mercer Bullard from the University of Mississippi, talking about branding compliance.
First, thank you all for being here. I really appreciate the invitation because this is the kind of conference with a lot of practitioners and future practitioners and industry insiders that I think really makes a much more valuable contribution. And I especially appreciate those who are in practice being here, although I guess when you're a former student, you have no choice, right? I'm actually going to talk much about technology. What I'm focusing more is on the compliance part of this. And this is an issue that I took up about 6 years ago when the idea was being floated as to whether there would be a self-regulatory organization for investment advisors. You're probably all familiar with FINRA being the SRO for broker-dealers. And when that idea was floated, one of the things I had been thinking about is compliance being done by outside third parties. And I convened a roundtable of some broker-dealer people, state regulators, technology people. The idea being that, why isn't there more technology out there that centralizes and makes much more efficient the compliance process? And at that point, I was an associated person of an investment advisor. And all of the reporting, for example, my quarterly reporting was done manually. And it just made me think, there's just got to be a market space here. I'm not working for them anymore, but before I left, Schwab had introduced an automated system, which now has made our technology, as terrifying as it might be, has actually saved a lot of money for the firm, and it has enhanced compliance because while you can forget to file your quarterly report and then never get around to it, if you are getting an email every other day from the technology monster, you eventually remember to do it. So I would expect the compliance is probably much higher as a result. So this talk is prompted by that idea of third-party examiners coming up again. And instead of it being what I envisioned, which would be this market whereby third-party examiners would establish solid brands to which the SEC would defer, and then accordingly would reward firms that had better compliance by doing exactly the opposite of what the SEC is trying to focus on now. They're trying to focus on more frequent exams. I think the SEC should be thinking about how to have less frequent exams. And that, to me, is really the contribution that technology can make and third-party examiners. Nonetheless, there is probably a better than 50-50 chance that I think this year, Chair White will float a proposal that will require that investment advisors have a third-party examiner. And the reason, the impetus for that is that going on about 6 or 7 years, the SEC and even the investment advisor community has bought into the idea that investment advisors are not examined frequently enough. And if you follow the industry, you've probably heard the data that somewhere around 1 in 10 advisors, or rather an advisor is examined about 1 in every 10 years or 1 in 9 years, depending on the year you're looking at. And the SEC has adopted the position that there is an inherent benefit to having more advisors examined more frequently. So I'm going to talk first about that, then I'm going to talk about what a third-party examiner might look like based on some of the models that we currently have in place or are about to abandon. And then third, I'm going to talk about way, I think the SEC should go forward, which would be a much more efficient approach that would both save advisors money and also enhance investor protection. So this idea of more frequent exams, obviously at the most simplistic level, if you examine a firm as opposed to not examining a firm, you are more likely to catch fraud. But that is about the depth of the SEC's analysis, and I suspect that you're not going to see much more cost-benefit analysis in the proposal. The problem with this higher frequency is necessarily good is that it operates in a context in which there's a view that there are infinite resources. And an infinite resource world is the only world in which you can say, per se, more examinations means more investor protection. In a finite resource world, what you are saying is that less of something else is a good thing if we then take those resources and we do more frequent inspections. So what would be the less of something else? Well, the SEC has long subscribed to the idea of targeted exams. And the targeted exams are often driven by the kinds of enforcement actions that have been on the rise, particular concerns of investors, pressure from Congress. They're kind of issue-based. They also will do exams for cause exams, which may be triggered by reports in the press about a particular advisor or something that they've learned about through a complaint. So there are a lot of other factors that would go into choosing whether to examine an advisor. And one of the most common ones has been size, because on a per unit basis, if you think about each, let's say, broker-dealer or the associated person of the advisor as the unit, on a per unit basis, you can do an exam of a large firm much more cheaply than you can a small firm. And because large firms as an institution may actually have more accessible funds in larger amounts, it is probably true that you get a lot more bang for your buck examining a large firm. That seems intuitively obvious. To give you an example of that, when Bernie Madoff finally registered as an investment advisor in, I think it was 2004, long after most of the fraud had occurred, when he registered, he had $17 billion under assets. And I would think that you would have a system that when a new advisor shows up as a registrant and has $17 billion, the next day you would send out a team. But what Chair White's proposal would do instead is say that these 10 firms in these 10 places, each of which may have $100 to $150 million in assets, each of which was probably examined as an investment advisor by states for years, we're going to go visit them instead. So that kind of trade-off really makes no sense unless you have actually done an analysis where what you think you're going to get in terms of your goals, let's assume they're investor protection and more efficient capital markets, which would include minimizing unnecessary expenses for advisors. If those are your goals, then you have to have decided that the incremental benefit of going back to examine an advisor based solely on their not having been examined most recently is going to create more than doing the targeted exam that you won't do because you are instead examining a firm solely because you haven't been there recently. And it won't matter what characteristics the firm has. It won't matter what size assets. And as we know, there's a lot of data that shows that the SEC may really be in the business of counting enforcement actions to make sure they add up to a certain number, rather than bringing the enforcement actions that achieve whatever the goals of enforcement actions are. And what you will probably see is exactly the same metric going on here. Because if you wanted to examine advisors on a more frequent basis, you would stop examining the large ones, because these counts are by registrant, they're by entity. And you would start examining a lot of small ones. Okay, so the problem here is that in order to survive possibly scrutiny by the DC Circuit, which has repeatedly vacated SEC rules for failure to do a cost-benefit analysis, they need to be able to show that there is a cost-benefit analysis that makes sense in requiring advisors to shell out funds solely for the purpose of having more frequent exams. And I haven't seen that in any of the SEC analysis. There was none of that in Commissioner Gallagher's speech in which he floated this idea. So one aspect of this proposal is probably going to be the key target when the proposal comes out. And I'm sure some of the people at the table will be reviewing comment letters and submitting them on the same issues. But again, I think it's more likely than not this proposal is coming out this year, and it is one of these things that just seems to be coming off totally unquestioned. It has a lot of investor advocate support, except me, who usually will take the investor advocate position. So the first part of this doesn't really have much of a basis. But since it's going to happen anyway, let's think about what are some of the models that we might look to and how they've worked out for us. And the most intensive model for a third-party compliance examiner has been NRSROs, nationally recognized statistical rating organizations. And in thinking about other types of third-party examiners, going through what they do and the powers they have, there were sort of generally 4 categories in which it's useful to think about their role. The first is whether they have essentially a legislative function. In other words, they actually create the standard that the regulated entity must follow. And then the second category would be that they also inspect and examine for compliance and even adjudicate compliance in some respect, in addition to legislating the standard that has to be followed. The third would be, what is the nature of the market in which they operate? Being third-party examiners means that there are other third-party examiners out there who could compete for the business. So is what we see a race to the bottom in the sense that you would simply go out and hire the third-party examiner that will give you whatever answers you want, right? Very common theme in corporate law. And then the fourth category is, what responsibility do they have for whatever it is they produce? And that would simply be liability. So if you look at those 4 categories in the NRSRO marketplace, what you see first is they are the source of law. In other words, they decide what the standard is that determines whether your issue, your offering, is going to get a AAA stamp. So in that sense, they're legislating the actual standard. Now, it's the SEC that says AAA gets you this, but it is the NRSRO that says these are the things that you have to do to get the AAA. Now, you could have modeled that where they didn't get to do anything else. They just put out standards, and then others had to go in and apply them, right? And that's what we use for public accounting firms. But the NRSRO also has all of the authority, once they've established the standard, of going in a way, inspecting and adjudicating whether you've met the standard. So they have both of those powers. Third, they operate in a market that, while you might think that it would cause a race to the bottom, where everybody would be tripping over everybody else and giving AAA ratings, that is consistent with what's actually happened, is that you had lots of AAA ratings that in the financial crisis were revealed to be based on very little solid analysis. And then fourth, historically, NRSROs have had virtually no liability. So you have a market in which they dominate the market, they are licensed, which means that not only is this market one that is completely consistent with collusive behavior, you have a market in which the government has given what somebody's already mentioned as the monopolistic power that a regulatory standard often creates. So in the NRSR model, you really have the most extreme form of third-party examiner, and at least Congress's most recent views on how that's worked out is that they have ordered that they be removed from all of the rules that are relying on their ratings for one purpose or another. And what's interesting now is that the NRSROs are now going to become another type of third-party examiner, which is the one I'll talk about in a minute, called GIPS. But let's move to one model that's fairly close to that, and that is the public accountant. And the public accountant, of course, does not make the rules. FASB makes the rules, so the public accounting firms are not the source of law. They don't serve a legislative function. They are the ones, however, who do the inspecting, and they are the ones who, in that sense, adjudicate compliance. They also live in a market that is extraordinarily concentrated. And again, you would think that there's this race to the bottom. It's very hard to tell what kind of consistency of reviews that you get from auditors because you don't really have that kind of public concrete information. But again, the market looks surprisingly a lot like the NRSRO market, with concentration among just a handful of firms. Unlike NRSROs, they have lots of liability. Okay? They are getting sued all the time, writing huge judgments, and have been lobbying for years in order to get Congress to basically eliminate their liability or impose a liability cap. Moving to another model, that is the chief compliance officer that you've heard about. This is usually an internal person, so arguably not a third-party compliance person, but the obligations that are imposed on a CCO are kind of like a third-party examiner obligation in that the SEC will call you out separately and say, you failed your CCO responsibilities. But they are internal. Now, a number of small firms externalize most or all of the CCO functions, and sometimes they even externalize, as I think somebody mentioned, the CCO position. And the SEC has gone in and specifically examined those externalized CCO functions. So what does the SEC, what powers have they given the CCO? Well, in the Advisors Act and the Investment Company Act, the rules are very different. In the Advisors Act, there's very little guidance as to what the CCO has to know, what kind of background that person has to have, does not have to be licensed, has some liability. But I'm not convinced by some of the views that that is actually a rising incidence of liability. Most of the CCO cases are CCOs who are also the business person who is engaged in the conduct. So I don't count those as CCO cases. If you look at pure CCO cases, I don't think there are enough to determine whether the SEC is going after them. But in any case, they clearly have that liability, that individualized liability. The market is huge, and it seems to be working in favor of a lot of people in this audience, because I've been telling my students for years, this is a place where a law degree can really, get you ahead. Okay. In that context, you also have, on the other hand, the mutual fund rule, where the rule itself includes some detailed guidance as to what the SEC insists be the characteristics of the CCO. And we've seen this in a couple of other contexts in areas where I'm not going to talk about in detail. For instance, the audit committee for a company now has to have someone who has specific training. So all of these are examples where you have different requirements applied to different types of third-party examiners. And they're all serving the same purpose of providing, in some structure or another, an independent evaluation of compliance. And in some cases, they've been handed the role of determining what the standard is that they will then be reviewing. So this brings us to, and there are a couple more you might want to just think about that I haven't really gotten into analyzing yet. One is that the SEC routinely requires mandatory compliance persons in an enforcement action. And those have a lot of really interesting details about the role the SEC plays in choosing them, in having their recommendations vetted, and backstopping that person. And usually it'll be a 2-year engagement, and they will often publish a 300, 400-page document. Another one you want to think about, and this is the 800-pound elephant, is the private attorneys general. And of course, the SEC historically has always said we view the securities laws as operating pursuant to the enforcement by private attorneys general and the SEC. One of the interesting aspects that's developed recently is whether Fair Funds Authority, which is the authority of the SEC essentially to become the private litigant and recover for plaintiffs, how that's affecting the incentives of plaintiffs' lawyers. Because in some cases, judges have said, look, the SEC already recovered everything here. Why are you filing in this case? In which case, you got to wonder whether there's a kind of displacement effect going on there. The last category I wanted to talk about, because it's closest to the model that I think would be the most efficient way to engage third-party examiners, would be GIPS. And those are Global Investment Performance Standards, which the advisor entities here are very familiar with. And they are privately issued by the CFA Institute. So the CFA Institute, in that sense, is the legislative source. But all they are is just one version of how you would comply with fairly calculated performance and fairly advertised performance, which is what GIPS applies to. How you calculate, how you advertise. And they have developed a strong enough brand that the overwhelming majority of institutional money managers now advertise GIPS compliance. Okay. GIPS, the CFA Institute, though, does not inspect or adjudicate. Instead, there are lots of entities out there that say, we're experts in GIPS, we will come in and do GIPS verification. And a lot of institutional advisors now have third-party verifiers come in and do that. GIPS has not been endorsed by the SEC, but they are seeking to require that investment advisors disclose whether they comply with GIPS. And that, to me, starts down the road of the kind of licensing that I think really removes the benefits of having a market for this kind of brand. And the way that I think GIPS should be rewarded is that the SEC, given that it is already examining for compliance with GIPS, and it is bringing enforcement actions if you say you're compliant and you don't comply, that they should be rewarded if the SEC thinks that this is a fairly reliable mechanism for calculating and advertising performance. And the reward would be infrequency of exams rather than greater frequency of exams. So the GIPS is a model. It's a model that is working. And it is a model that, if it's left in the private sphere, probably will have competitors at some point as the use of GIPS trickles down from the institutional managers to retail financial planners. So the idea of the GIPS model kind of fits what I would view as the right way to go about dealing with third-party examiners. And that is that the SEC should always be thinking about what is the flip side of its proposals. And I haven't seen any comments out of the SEC whatsoever as to what is not going to be done if you more frequently examine advisors. One answer we've gotten is that they're shifting examination staff from broker-dealers to investment advisors. Now, if that's because the optimal allocation would suggest that that be done, that makes sense. But it is clear the only reason the SEC is doing it is to increase the frequency of exams of investment advisors. Now, the problem with that generally is that broker-dealers are inherently more susceptible to fraud. And the reason is broker-dealers effect transactions. That's what makes you the broker-dealer, or you act as principal in a trade. You also have custody. You also provide the reporting. And if you want to look at all of the major frauds where investors are losing significant money, it's affecting transactions, custody, reporting, and the incidence of sort of services that are provided that are not central to investment advisors. Now, what this would militate for is having more examinations of investment advisors who have some degree of custody, because there's a category of advisors who have to disclose that they have custody, and they do get examined on that front. That would be at least targeted based on the real risk. But if an investment advisor who does not do its own reporting, which is where you see a lot of fraud, does not have any custody, does not effect transactions, because all of those things are being done by qualified custodians or registered large broker-dealers, then why are we going to more frequently examine then, rather than look at really the root cause, which should be the root cause of every examination, is that it fits some kind of conceptual model, not necessarily a precise one, but a model of what it is we're trying to accomplish with examinations, how we're going to measure that, and then how are we going to change how we do examinations in response to that. Thank you.
We're ready for some commentary. So the first commentator is Jonathan Gottlieb.
Okay, hi everyone. It's great to be here today. In looking at the topic for the symposium, I kind of thought back across the timeline of my career, which at this point, believe it or not, spans close to 30 years. I started out in the financial services industry actually working on a trading desk in the mid-'80s. And, what the industry looked like back then compared to what it looks like now is almost unrecognizable. On the trading desk, we still had, basically timestamps, and people would write out tickets. And, there would be supervisors that actually sat on the desk and actually were able to look at every trade and knew what was going on. There were like clerks that actually had these T accounts of long and shorts and calculated whether or not, the position was hedged. And you'd have a morning meeting and you'd go through all the positions. And you kind of think about where we are now with, nanosecond executions of, hundreds of millions of dollars worth of transactions. It's really truly astounding. But I think when the industry was smaller like that, where the first line of defense, the supervisor, was on the desk and able to oversee it, compliance was a little bit more in the background back then than it is now. But obviously with the evolution of the business and this rapid transformation, that's no longer, really possible. I also got to witness kind of firsthand kind of where the regulators were at from a technological perspective. After my stint on a trading desk, I came back to Brooklyn Law School, and then after Brooklyn Law School, took a job at the SEC in 1992. And when I joined the SEC, they did have personal computers, but it was, there was no servers. I don't think we were up on email yet. I was talking to John Walsh, who was on one of the earlier panels, and he actually worked in a unit in Washington, D.C. that would review the enforcement recommendations that were being made by the regional office lawyers, and actually had to fax the memo to him so that he could review it. It was like there was a stage right before we got email. And believe it or not, when I was at the SEC, I actually did what I think was the first case involving fraud on the internet. HJ actually did that case with me. And also another, believe it or not, the SEC, at least our office of the SEC, didn't even have access to the internet, and I actually had never even logged into the internet. I brought the case basically based on, somebody in the home office who, did have access, faxed me a printout of some of the fraudulent statements that were being, made on some chat room. And kind of based on that, we went in and got a temporary restraining order, to halt the fraud on the internet. And believe it or not, I even had to define what the internet was in the complaint, which is like a series of linked computers, and I don't remember the exact definition. And even more embarrassing, I actually misspelled internet. I did it INTER dash capital NET, which if anybody goes back and looks at that, it's a little bit embarrassing. So from the SEC, I then went to my first in-house job, and I'd say technology was continuing to advance during that time frame. I think there was a reference to Y2K, and everybody thought the whole world was going to blow up when at least the computerized world was going to blow up. When we got to 3 zeros. When we lost the 19 and went to 20. At that first in-house job, we were starting to see like the early stages of electronic trading, or at least kind of like in proposal kind of form. And actually, the company that I was at was looking into starting what would now be kind of viewed quite commonly as an alternative trading system, which basically allows customers to access multiple dealers' inventory to basically buy or sell securities. But kind of at the time, the regulations didn't really work because it would be way too onerous. The model basically fit more aptly into like a stock exchange than it did anything else, and kind of the hurdles to become a stock exchange were kind of tremendous and off-putting enough that it was kind of a barrier to entry. And kind of based on those efforts, the SEC passed Regulation ATS, which in effect allows these systems to register as broker-dealers, but subject to certain additional requirements. So clearly, the industry has changed. I agree with Tom's observations about the transformation of the financial industry, generally. Just the increasing complexity of instruments, strategies, the high-speed executions, increased trade volumes, and certainly, the impact that has had, the way firms have to approach supervision, compliance, and risk management. I also agree with the conclusion that technology cannot replace effective lawyers and compliance officers, because clearly nuanced judgments are needed. I thought on one of the earlier panels, kind of the example of like a brick wall and kind of traders and business people kind of operating kind of between the cracks. I think that is like very apropos, and technology can kind of be designed often around kind of like black and white type of issues, but I think our business kind of operates trying to operate within the requirements of the laws and the rules, but there's certainly a lot of gray, and I think that's where kind of the human touch comes into play. And again, I think on the technology front, technology, can definitely provide a false sense of security, because it's only as good as the people that kind of create it, whatever the algorithms, the search terms, whatever. If they're not the right ones, compliance officers, risk managers, supervisors can just keep going along thinking that everything is great. I think, there's some, Tom mentioned some of the, different kind of scandals and rogue trader incidents, and every CCO and general counsel and their teams, I think, are always, every time one of those issues comes up, they're certainly always focusing in on, could that happen here? How can I prevent, will my tools have prevented it? And if they don't, how can I fix, my compliance tools to prevent that from occurring in the future? And so again, like as we kind of talked about the rapidity of executions and the like, direct human oversight is no longer enough as it was kind of very early on in my career. There's no way that these businesses can be supervised without technology. But kind of as I alluded to, it's like if the search terms and such aren't correct, a massive fraud can continue. An example that kind of comes to mind is a major hedge fund that's been in the news. Various traders that work there indicted for insider trading, major SEC action against the fund, that they failed to, act appropriately in terms of controlling the activity at the firm. I think that this firm had kind of like state-of-the-art electronic communication surveillance, CIA caliber, but for some reason, when the SEC did their investigation, every email from the individual traders that were alleged to have traded inside information to the head of the fund used the term "I have edge" on this name. And so the term edge, at least from the SEC's perspective, was synonymous with material non-public information. However, the greatest electronic communications technology in the world failed to pick that up because whoever programmed that tool was not aware of or chose not to use the term edge. Another SEC case comes to mind against a firm for basically failing to supervise a trader who, in effect, wasn't lying about the security itself or the value of the security, but was basically making misrepresentations as to whether or not he owned that security in his inventory or was acquiring it for that particular customer. And this individual also, was alleged to misrepresent kind of the price that he paid for it and how much money he was making on the trade. And again, the firm, and the SEC in its action and the settled action against the firm basically kind of criticized the firm for not having appropriate email surveillance. And I think here it highlights, I think, a technological challenge because the misrepresentations kind of related to whether or not the security was held in the trader's position, but without kind of linking the electronic communication surveillance system to the trader's inventory, the technology would have no way of knowing that. And similarly, as it relates to how much the trader paid for the security, if there's no linkage between technologies, there may necessarily kind of be a failure. So in terms of kind of the connection between technology and human interaction and the importance of human interaction, at the time I joined my current firm, we all got these pencil holders that had the legal and compliance department principles, which I happened to notice as I was thinking about my remarks today, and I thought that they were valuable. They were to be visible, be proactive, be user-friendly, maintain high standards, follow through on problems, maintain independence, know the business and products. And in thinking about those principles, kind of reinforced, what is my belief that the lawyer or compliance officer who acts as an independent but trusted advisor who is visible, knowledgeable, and proactively engaged with the business will be best situated to identify potential compliance issues before they occur. With technology alone, the hope is that you identify something real time or early enough before they become too significant. But I think the way to prevent things, from happening in the first place is, I think, through kind of direct interaction and involvement by legal and compliance staff. And I think what Rebecca said earlier completely resonated with me, that having a seat at the table, being next to the business at those meetings where you can flag and have discussion points on things, I think goes a long way to preventing problems before they occur.
Great. Thank you, Jonathan, for your perspective. HJ?
Sure. Thanks for having me. I appreciate it. It's been a great day. Just 2 seconds on my background. I work at a firm called AQR. There's my phone right there.
Calling them now. They're a very tech-savvy place.
We don't do anything on email. No, just kidding. Based in Greenwich, Connecticut, 140 billion quantitative manager. So we rely on models all the time. And a key part of compliance and trying to figure out the compliance's role in that model development is a huge part of what I do, and a huge part of what my team does. So the issues that we've been talking about today is something that we are wrestling with all the time. Where does compliance fit in? Because essentially what we are is a software company. So we have researchers, we have internet, IT personnel, both in Greenwich and offshore, developing models, designing models, testing models. We have QA. We are a software development company for all intents and purposes. We don't view ourselves as having magic sauce around those models. It's more around information processing. So where a fundamental manager might look at 500 stocks in a year, we can look at 5,000. So it's really processing that information, pulling in data, and then using that to generate views around certain strategies. So it's an exciting place to work. It's incredible in this environment to have to try to design and build a compliance program. So with that perspective, on balance, I think even having listened to a lot of it today, technology is good for compliance. I think from where I started, talking about Jonathan and starting at the SEC and working my way through the industry, technology has obviously gotten exponentially better. From a compliance perspective, we have better tools. We have real-time access to information. We can run better tests. We can run things and analyses in a more timely fashion. We can put controls on certain things. So like when Professor Carmel was talking about her first job, yelling yes or no, we can build those checks into our processes, right? So when people hear about using algos to trade, those algos can have the controls built into them. And we can test whether those are effective or not. So that all those kinds of things, getting away from people doing transactions on the phone and face-to-face, I think the technology adds to the control environment. It has not been job eliminating. It's kind of like when, in my space, when firms first kind of dip their toe in the water and hire their first general counsel, their first CCO, they think we can eliminate all the outside legal fees because now we've got a lawyer in-house. And actually they realize their legal fees explode because now the lawyer in-house is recognizing all the issues and all the help he needs. It's kind of the same thing with the technology, I think, with respect to compliance. We're able to identify more issues, and as a result, compliance officers have to analyze those issues, determine what we need to do in response to those issues, whether we need policies and procedures, additional training, all of that kind of thing needs to be done by humans and often by lawyers. I think clearly technology, again, this is probably for better or for worse, has been a boon for the regulators. Their job is way easier as a result of the technology. It's not even comparable when you think about how Jonathan and I had to try to put cases together. The access they have to our information, both from what we push out to them from a regulatory reporting standpoint, and the sophistication they've built internally that was talked about earlier. They are in a way better place to identify misconduct, in my opinion. And then lastly, and most importantly, I think the investing public is way better as a result of the technology. If you think about how we have access to markets, how you can trade stock at 2 in the morning, you can look at your balances, you can look at the settlements, liquidity in the markets, the settlement periods have tightened. The prices have gotten more transparent. So I think all of that has been a net win. Along with that, like we've been talking about all day, there are tons of challenges and threats. And the challenges I touched on earlier is trying to build some oversight around this. And where should compliance be? Over the last few years, the SEC has talked about quantitative investment firms in the role of compliance. There's a case called AXA Rosenberg, where a model error went undetected for a number of years. Once it was detected, the firm failed to escalate it, and the SEC whacked them pretty hard. It was a real shot across the bow for firms in our space. And as a result of that, the SEC got a little bit smarter around quantitative investing, and there were some speeches around compliance should be evaluating the code. That would be a monumental effort to, number one, be able to attract that kind of talent. Somebody who's a software engineer or a programmer, and I want to bring you over, don't make cool apps or software, come work for compliance. But if I overcame that, code can't be evaluated that way. That's really not how you do it. You need a time series. You need a QA environment. So that's really not the good place for compliance. What our approach has been, and I think most of the quant firms would agree with this, is building standards around it. So looking at how software firms develop their software, what are the controls they have in place, and documenting those, and documenting how we comply with those procedures. But it is a process, constantly getting better, looking at how the industry is doing things and evaluating where we can add value there. But I don't have that kind of expertise. I have guys that can code and query tables and generate reports and things like that. Absolutely, that's on the team. I have very talented technology managers, in other words, project managers within compliance. We call it business and regulatory change within the team, and they quarterback key compliance IT projects. But I don't have somebody that can actually sit down and look at a line of code and evaluate whether that's going to be effective or not. And I would question whether the regulators have that ability either. I do think another challenge for the technological developments that we've seen, and Tom touched on this, is maintaining the relationships with the business. That's still key, and others talked about it. We can't be siloed off. We have to be involved in the business. You can have a central surveillance team, absolutely, but I do encourage my team to be in the business, to be in front of the business people. If you're able to develop those relationships, that's how the issues get brought up, and that's how the questions get asked before hopefully the conduct starts or the harmful conduct starts. So that's key. It's key to maintaining the culture and values by being out there and making sure people know your face and that you can address their issues and their questions. The other issue with technology is, and this was touched on earlier as well, is we're storing a lot of data. I mean, there's a ton of data within the four walls, and when you start storing stuff like that, you have to do something with it from a compliance perspective. So surveillance is key. I would say the tools over the last 3 to 5 years around surveillance have gotten way better for the buy side. The banks have always been kind of out in front on that, but it's been cost prohibitive for investment advisors. That's starting to change. So we will, I think you'll see the hedge fund industry, the alternative industry, continue to get better in that space on the surveillance side. Email surveillance, behavioral analysis of emails, all that stuff, a lot of that stuff's already in place. But I think the real kind of trading surveillance that banks have been doing for years and the broker-dealers will continue to migrate to the alternative space. And then, lastly, to have this technology, you need a robust infrastructure. So we have over 600 employees at AQR, most in Greenwich. I'd say more than a third of that are IT professionals. And as a result, and this was talked about earlier, I think Richard talked about it, as a result of not only the technology in the business, but then the regulatory framework on top of it and what we need to respond to, it has become a real barrier to entry. And I think you will see the smaller firms struggle under the weight of, required technology to meet the regulatory obligations. And then obviously cybersecurity. So huge focus. We have a chief information security officer. We work very closely with them. There's a number of things we pay attention to internally, but that's obviously a focus for us, both internally and externally, trying to evaluate that threat. The thing that's disappointing from our perspective, I think from the industry, and certainly speaking for myself, is the regulatory environment around cybersecurity. That it's been kind of, in my opinion, bootstrapped into a compliance matter. I think we would have a much more effective defense if it was collaborative with the government, collaborative throughout the industry. And I think we're going to get there. The industry will push in this direction, and there's already starting to be more and more cooperation across firms. I think the banking industry has a lot of that, but in our space, we're going to get there. So understanding what, is there a new threat out there, and being able to share that across firms. But I hope the government will think about that, and I hope the SEC will consider that, because the idea of getting hit with a cyber attack and having to recover from that from a client perspective, and then walk into an enforcement matter, just feels like you're suing the bank that just got robbed. In terms of to talk about Professor Bullard's paper on the outsourcing, it's like a fascinating question. We are GIPS compliant. That really goes to how we present our performance numbers. We have to have written policies and procedures. They are verified every year. I think the challenge for the outsourcing thing, this is why it's so surprising that the SEC is pushing this, is the idea that they would defer. That they would, and John Walsh talked about it earlier, they love the far-reaching exams, right? So they may come in and it be targeted, they find something, they want to follow that, and they want to chase that down. Talk to more people, pull more emails, pull more documents. It's a very kind of iterative process when an exam's going on. I think one reason why the industry would be interested in outsourcing is I think it's probably an effort to have standardization around it, right? So like how the public accounting side, like GIPS has, like here are the 25 things you have to do. I think the industry would obviously view that as helpful. I think there would just have to be like this overarching framework over the third parties. I just don't know if the SEC would be willing to hand the keys over. I think I view ourselves as being at a big firm. We view ourselves on a 2 or 3 year cycle, and we need to be ready at all times. I've got a team embedded in compliance that does testing and exam readiness. That's what we're doing all the time. We're looking at what their priorities are. We're looking at recent enforcement cases and evaluating what we're doing, talking to outside counsel in terms of our policies and procedures. That stuff never stops. You have to always be in that mindset. Using outside firms to test, using outside firms to evaluate what we're doing. There's enough of them out there now. The compliance world has become an industry of itself. Obviously, from this room, there are technology firms dedicated just to compliance. There are obviously consulting firms. The law firms obviously are very much focused on this. That will only continue. But I think as we move forward from a technological standpoint, I think people have talked about getting complacent or compliance falling behind. I haven't seen that. I think the resources are continuing to be deployed in this area, but that's always kind of a challenge. But the world is complex, and it is can be scary at times. But I do think we're in a much better place from that standpoint.
Great, thank you, HJ. Lastly, Robert.
Thank you. I'd like to thank Professors Fantone and Pinto, the journal, and the school for having me here to speak. As the two people presented their papers, I felt like I was sitting at Peter Luger's with a big steak and a nice bottle of Napa. I was just ready to dive in with really everything that they said. Overall, I kind of agree with most of what they said in terms of how outsourcing is possibly coming, how technology is really impacting the industry. But before I start eating my steak, I will just give you my quick background on myself, which will help you give you the context that my comments come from. So I graduated here in '85. I started representing hedge fund managers in 1986. And so I've represented the hedge fund industry for just about 30 years. I can't really speak about the registered fund side, so that's not what I do. And they're also all registered investment advisors, so I can't really go there. I just know our industry. And so I've watched it grow, I've bled with it, and I've done well with it. It's not necessarily as depicted on Showtime in the series Billions, although I don't think that shows the industry that bad. So I'm going to just, I guess, break it into the two papers, but I think it'll come together. So the idea of self-regulation for registered investment advisors, it's an interesting idea. So what we face and have faced for the last number of years as an industry, it's the hedge fund industry, throughout the late 90s and 2000s, there were hedge fund managers that registered with the SEC. They may have registered because they were required to, or they registered because it was the right thing to do from a marketing perspective. And then with the financial crisis and Dodd-Frank, everyone else was required to register. The issue that we faced on examinations, and still face, is that the examiners, by and large, while they're trying, they don't understand the industry, they don't understand, and every manager is different, and we feel like a lot of the time we're training them rather than them asking us the right questions. I think every client, every hedge fund manager out there wants to perform and deliver to the examiner. They want to show, hey, we've been working on this, just as HJ said, you have a whole team. Everyone does. It's not, in some ways, when I sometimes, hear the news or I hear people in government speak, it's like they think like it's the Wild West, or there's just
We're
a
not
person
trying.
that we're not trying. So a really great example of something, by the way, and it ties cybersecurity in, is, so the SEC came out with like a concept paper, I don't know whether it was 18 months ago or so, on cybersecurity. They hadn't mentioned it before, and it was in the investment management side, and they came out and they kind of, there's something called NISHIT, which is, I can't even pronounce what it is, but it looks at cybersecurity. It's like an institute that looks at cybersecurity issues, and the SEC published 27 or 28 things that they thought hedge fund managers should look at. And it really lit a fire under everyone's, case. Everyone started thinking about, what do we need to do? I was getting calls, can you send me over folks at my firm who deal with cybersecurity on behalf of the banks and behalf of, Fortune 500 companies, and they laughed at me. Like, what are you talking about? Like, we have, a 150-page, 200-page, document that, somebody has. That's not going to, it has to be something that's customized for what people do. So I'd venture to guess you don't have a separate defined policy. It permeates everything that you do at this point, HJ, right?
We have an incident response
Yeah,
plan.
you have the incident response plan, yeah. So I thought of all the things that came out of Dodd-Frank from a practical perspective, and not that the cybersecurity statement came really out of Dodd-Frank, but it really got everyone thinking about it. And it has managers testing what they're doing, thinking about what they need to do. It's a different world, right? So a hedge fund manager doesn't have, it doesn't have a lot of information on retail investors. It doesn't have retail investors. But certain types of hedge fund managers can suffer serious consequences. Quant managers, for example, what AQR and many others do, to me, that's the scariest thing of all. And I know that you're scared, and I'm sorry I'm bringing it up.
Yeah.
But because if someone could hack into what they're doing and all of a sudden be trading billions of billions of shares of securities in a nanosecond, we have a much bigger problem. So, good example of the SEC doing something. Thinking about having an outside parties examining us doesn't make any sense to me. Don't know what the standards are. As HJ said, I mean, they have outside people that come in. They hire folks that come in. There's a whole industry of folks who come in and can do it. Law firms go in and do it. And then, everyone within their own shop goes and does it. What I spend a lot of my days doing, instead of building, which is what I like to do, building funds, building products, I spend a lot of my day speaking with general counsel and chief compliance officers at funds on compliance-related questions. I heard that the SEC is looking at this. I heard that they're doing this. For me, from my perspective, it would be great if they would just come up with standards. This is what we want you to do, rather than playing gotcha. And unfortunately, I feel like Mr. Rubio right now, excuse me. I could do this all day. In fact, I could talk for hours on this, and I think cocktails next, Arthur? I forgot what I was just saying. I got so caught up in that. But let me just talk about the types of exams that the SEC has done, and try to think about having an outside party do this. They do phone exams now. I don't know whether people are aware of that. So they'll send an email or a fax. They still use fax, which is pretty amazing. Saying, we're going to call you, Thursday at 2 o'clock for an hour. We'd like you and a principal on the phone. They do that really with newly registered managers. Excuse me, I think they do that so they can check the box saying that, we saw that manager. They do one-day exams where they'll ask, they'll send a request list, and they'll come in about 2 weeks later after you've given them all your documents, and they'll just spend one day and then go away, and they'll ask some additional questions and then generally come back with a deficiency letter. In almost all cases, what you're dealing with is I'll keep saying, it's a game of gotcha, rather than how do we do that? How do we work together to help you with your policies and procedures, things that we've seen at other funds? Here's what we could see you guys doing if you have the resources to do it. Instead of that, it's gotcha, which is unfortunate. And then they have what are called regular exams, which they claim they're not doing anymore. But regular exams would be they would come in, and depending on the size and nature of your business, they'd spend, a week, 2 weeks, sometimes months in your shop asking questions, reviewing documents, going through things. Not necessarily a pleasant thing. And then they have for-cause exams. Maybe that term's not correct anymore, but where they've gotten a complaint, a tip, a referral from another group. So when you get the exam letter from them, it's clear they're looking at something. They don't tell you it's a for cause, but it's clear they're looking for something. I find it interesting that, a few months ago, the SEC indicated they were shifting about 100 examiners from doing broker-dealers to registered investment advisors. And I found it interesting that you brought up Bernie Madoff because, and you correctly said, Madoff probably committed 98% of his fraud as a registered broker-dealer, and he had been examined by the very people that they're moving over. So that gets me really excited that investors are going to be safe on the who have money with registered investment advisors. I look at it this way. I think that in most cases, or in many cases, the idea of checks and balances is very good to have. So it's very good to have checks on people who are managing other people's money. And principally in the hedge fund world, the checks are done by the investors. And I think that the investors are in a much better position to understand what the hedge fund managers are doing and to be able to ask questions and dig in and get details and to force and cause the managers to change behavior, to modify behavior, to meet standards and norms that the investors are looking for. And I think that's what I have seen over all the years I've done it. The investors are way out ahead of the government in things occurring. I'm sure you guys have seen that. You modify your behavior more to the people who are giving you the money than you do to the government that's playing gotcha. Now, if the government instead of playing gotcha, they said, let's find ways to do these things together. Let's develop a system, for example, in cybersecurity, where we can have a central clearinghouse for, attacks that are occurring, so we can all share that. That would be something that would be fantastic. But the shift of people over, it cracks me up because they didn't do such a good job before. I guess another thing to think about is what are the goals of exams? So, the goal of the exam, is it to play gotcha, to say, hey, we examined X number of managers and we issued X number of deficiency letters. We referred 10% of our, exams to enforcement, and enforcement brought all these actions? Or should the, purpose of the exam be to make the industry better, to make it more efficient, to make it more transparent for investors, transparent to the government where it needs to be? I mean, that to me is, where I believe, the goal should be, developing best practices. And again, as I said, what they did with the cybersecurity release was fantastic. They've now come out and said the examination group at the SEC has come out with their priorities for 2016. And one of their priorities is now, so they went out and looked at investment managers as well as broker-dealers to see whether they had cybersecurity policies and procedures. In 2016 now, they plan on going out and testing those policies and procedures. I hope they have people who actually know what they're doing if they're going to go out and do that. Otherwise, again, they're causing the HJs and the Jonathans of the world to spin their wheels rather than doing what they do best, which is working on assisting the company in complying with the laws and protecting the investors. So I would hope that would be there. I'm not sure that third-party examiners on the outside without substantial training and without clear guidelines are going to get anywhere. I know that the chair of the SEC wants this to occur. We had a little discussion beforehand. I'm of the belief that we may not get the additional 2 commissioners, or if we get them, it'll be late in the year. I don't know. Maybe it'll be in March. But I don't think we'll have a final rule this year. I think maybe we'll have a proposal on it. I also was at an event a couple days ago where a former head of investment management who had come from the hedge fund industry was speaking, and he too said that Mary Jo White really wants to have this proposal, and so we'll see whether she can get it or whether, with a change of administration, whether it stays on the Democratic side or whatever the Republican party becomes in sides, and maybe three sides, whoever takes over, whether that will continue to be something that's there. I like GIPS. I think it's a great, I think it's been around for a while now, and I think it's a good compliance tool. I'm glad you guys use it. Most large funds are GIPS compliant in the hedge fund side. On the technology side, I apologize, I didn't make the earlier part of this. So I was meeting with a manager who is a big data manager. So, and I was meeting with him, with my tech partners, and with my securities enforcement partners. So what he does is he has either outside folks, or he's thinking of bringing some former CIA, NSA people in-house, and they mine information on the internet. They go to places that none of us can go. You certainly couldn't go when you didn't know how to spell it, but so they go places, and so there's a tremendous body of law that hasn't yet been created. It's being created on what information you can take, that you can find. Can you take it? Can you use it for commercial purposes? Any website you go to has a terms of use provision, and I'm sure nobody's ever gone and looked at them, but if you go and look at them, for example, it may say you can only use the information for personal purposes. You can't you can't gather information using a computer. Like I learned a term today, spidering. I don't know if I didn't know. Does anyone know what spidering is? Show of hands. Okay. So I'll leave it. So I don't want to bring you into the next century. So we'll leave that. We'll leave that so you guys can go look at it. Yeah, you can Google it.
That's
yeah.
innocent.
You may have an NSA person call you, but that's fine. So we spent a lot of time talking about again, technology and how technology is used, what my client is going to do, right? They need to write a variety of different code in order to be able to take the information. So again, fascinating things. They take pictures of, Walmart parking lots from satellites. And you have thousands and thousands of pictures, and you write a program that decides how to look at those pictures and do things, and you come up with an idea as to whether things are going better, not as good, could be better. Crazy stuff. So that's why I missed this morning. I was dealing with that. When I talk to my quant clients, when I talk to the CCOs, we have the same discussion all the time about, do they really want us to understand the code? The answer is, there's no way you can understand the code. And what you said is absolutely spot on. You have to look to what others in other industries are doing. You have to spend a lot of time talking to people in your shop, asking them questions. How does this work? What happens if it doesn't work? What happens if there's a flaw in the program? How do we do that? Because that's what a chief compliance officer should be doing at any shop that has that type of technology. I can remember back, it's probably 1989, I had a client, he was managing $100 million, which in our world today is a very small amount. But, okay, I got one? All right, I'll finish with this story. So back then, $100 million, you were king or queen of the world, if you imagine $100 million in a hedge fund. He calls me up and says, I just got off the phone with somebody from the SEC. They asked me some questions. I said, where were they from? He goes, enforcement or something? I said, so I tried to gather information from him. So what they had asked him was about they wanted records from a particular company name that he had been in and had traded in. And I said, what'd you tell them? Because I said, what you should have told them was, let me have your name, your phone number, and I'll have my lawyer call you, which is absolutely a normal response to give. So, the training began that day for me with clients. You do not speak to anyone. And it's perfectly okay to get, name, rank, and serial number and then have someone call back. But he said, he told them that, because they wanted all of his research and notes about a company he had traded in, and he told them that that was like 6 months ago. I had their 10K and their 10Q on the floor of my office, but I don't have anything anymore. Today, if that call were to come in, the trader or the portfolio manager wouldn't have the conversation. It would go to probably the general counsel, who would probably return the call, But there would be reams and reams of information that had been stored relating to particular investment theses, and so it's just a completely different world that we're in. With that, I've been told that I can't talk for a few more hours.
Thank you very, very much. Let me make just two quick comments that when I read the papers, and then we have time for a few questions, hopefully. Tom's paper was a scary thing to read, and of course, when you read something scary, you want it to end with everybody feeling good, which you don't, and particularly on the systematic risk issues where you don't expect necessarily industry to be able to deal with that. Someone has to deal with it, and I hope your next paper, or whoever reads this, decides to take that on. And just briefly on Mercer's paper, I thought it was quite an interesting paper. I would just like you to talk more about the downsides of your proposal, not here, but in the paper itself. What downsides? Yeah. Anyway, open up for some questions from the floor. Yep. Whoops, go ahead. Yep.
What challenges do you see coming from social media?
We've turned it off.
We have also.
Yeah, that's something that's progressed over time. It was not on our radar screen, 5 or 6 years ago, and then we had an employee posting stuff that just kind of made us nervous. But I think most of the larger financial institutions block access during the day. You can read it because some people are that's how they communicate with their family and stuff, but you can't post. It's used for business a little bit. We use it a little bit for marketing. I think the bigger institutions use it more, but for the most part, we've limited access. Now, we don't prohibit employees from showing up with their phones, right? So there's only so much you can do. There are financial organizations that prevent employees from bringing their phones to the office, or they have to turn them in before they walk in the offices. So
that's more extreme than us. We don't allow sales and trading to have their phones on the trading floor. Kind of in the environment where everything's recorded. You just don't even want the appearance of the possibility that they could be, hanging up on the tape line and picking up their personal line.
Or taking pictures of
screens
or
yeah,
or
exactly.
systems.
Yeah.
Yeah, the SEC is focused on the testimonial issue, which is prohibited from investment advisors. And at one point, they took the position that a light constituted a testimonial and was prohibited. And at the same time, the Massachusetts Securities Division came out with the opposite position, that it wasn't. And I don't know if the SEC, has the SEC withdrawn that position yet? Or
they did give more guidance, I think.
I think they still,
Yeah.
and then when my firm required that we not allow anyone to recommend us on LinkedIn. So if you see advisors with no recommendations on LinkedIn, that doesn't necessarily mean that no one wants to recommend them.
No, that's actually the right tech to
Right,
take.
so
Yeah.
that's what everybody does. And there's actually, and that, we now automated that. So there's this outside firm that kept sending me this automatic email saying, you haven't given us some kind of authority over your LinkedIn to do something to it. But yeah, and don't bet on the regulators understanding how the social media work.
Well, I hope the social media covers this conference. Go ahead, Jim.
Well, I was encouraged to hear that, from HJ and the others, that you don't have to become a coder, to do compliance. Even though I have to say, I've taught in this NRO program for the last 5 or 6 years, where you have CCOs and COs come in. And it's funny, like every year, I ask people, what do you do, what's your background? More and more, compliance officers say, well, yeah, I have a tech background. I actually am a coder. And I said, well, why, and they're hired for that reason. So, I'm just wondering how long this can go on, because when you do see some of the SEC disciplinary actions in this area, and they start saying, well, you didn't know how this code would, spill out those
Sure.
orders. Now, it could be, with your interaction, but it makes me wonder,
Yeah, no,
how
absolutely.
many do you have to bring on your side of the wall just to, but, you said, how you can entice them over there.
Right, it's hard. It's definitely hard. I still think there are ways to provide effective oversight without having to be in the middle of that. And it's requiring, training, documentation, getting guys to raise their hands, and that's the relationship thing. So I have to, we have to build those relationships with the guys that are building that stuff. And also, you know, putting accountability on senior managers, right? So people who are in line of supervising those folks. It shouldn't just be the guy banging out the code and then compliance, right? There's a whole infrastructure that should be overseeing that and confirming the performance and it's performing as we expected and things like that.
And I just wanted to, you, Mercy, you know, maybe you should think of doing a big paper on examinations. I mean, is there any, like, really good stuff about the total examination? I mean, you're just looking at the third party.
Yeah, there's very little data.
Right? Very
And in
little.
fact, for example, most people think of the exam itself as what's really burdensome. It's the pre-exam document production and it's the post-exam deficiency letter responses. That's probably 80% of the work.
Yeah, and then dealing with
Huge amount.
your investor base
Investor base,
as
right.
to whether you're going to share it or not, and it's basically impossible to negotiate the deficiency letter before they give it to you, and frequently there's things in there that just, again, don't make sense. You just respond to it, but they shouldn't have been in there in the first place.
Yeah.
Well, you know, one empirical piece, I'd like to hear if you think it's worth it, would be to do what was done for the SEC's enforcement action counting. Because the SEC routinely says something originated in an examination. And in my paper, I have an example where it originated in an examination with respect to misconduct that occurred between January and July. So I just went back and took a look at it. It was in the press in August, and the class actions had been filed in September. So unless the SEC had actually examined them in July, the SEC was the last to know, and it didn't originate whatsoever in their exam. But they make that claim, and they make that a lot in their annual reports.
They probably read the paper and sent in an exam.
That's, the first case I worked on in private practice, it was all over the papers long before the SEC.
Yeah, but as Robert says, a lot of it's nitpicky stuff, and then how do you even get your hands on the kind of data to see? But, you know, it's the issue you raised. It's like, well, what are you doing? You know, and how effective other than kind of
It's the number of
the
exams. Number of exams, number of enforcement actions.
Well, on that note, thank you very much. I want to thank all of the participants. I want to thank the journal and my colleague, a good friend, Jim Pinto, who did a terrific job putting this together.
Thanks for everybody for coming.